Do we have too much government?
We need to put people ahead of corporate profits.
This system is so lopsided.
This threat is a real threat to democracy.
And I think that's really important. That's something we haven't been doing in this country for a long time.
Where do you start? What do you do? How do you do it?
Access to Democracy and other Eagan community television programming is supported by Thomson Reuters, makers of Westlaw Next and based in Eagan. Through Westlaw Next and other innovative online services, Thomson Reuters is the world's leading source of intelligent information for businesses and professionals. Online at thomsonreuters.com. And by U.S. Federal Credit Union, the member-owned financial institution offering service, value, and experience you can trust to the greater Twin Cities community.
Welcome. It's Access to Democracy, and we have a return guest who I was just speaking with, and when I said this is going to be your 17th appearance on the show, Justice Paul Anderson of the Supreme Court said, I almost fell out of my chair.
Yeah, I did not realize that I'd been on the show that many times, but
we go back to 2002.
I mean, it really is. It causes me to think as to what a historical record that you've developed with this show, and I surely hope the Historical Society or some entity like that, preserves all the interviews you had, because it is truly a living Minnesota history that you've captured on this show.
Well, not only have you been here, but you have brought us 2 Chief Justices and another Justice from the Supreme Court, as well as I think we've had Judge Asfung when she was running. And of course, I've had Court of Appeals judges, district court judges, and people running for office to become judges. So we have much to my surprise.
I don't think you've had our most recent justice, Justice Strauss, and I think you said...
No, I'd look forward to having him on here.
I would guess it, because he's quite interesting, and it brings a different nuance to the court. But anyway, it's a pleasure to be back, sir.
Well, it's always a pleasure to have you. You look rested and healthy and tanned. I am none of the above.
Well, I'm not necessarily rested. I'm tanned. We have a lake place, and the lake is up, and it's damaged the wall, and I've been wrestling with railroad ties, 8.5-foot railroad ties, pretty big, and some rocks and whatever. And my wife complains about it, and my daughter says, oh, Dad, it's all about leverage. And at my age, it is all about leverage.
That's the other side of justice that we don't necessarily see.
Yes.
Yes. So we've talked about a lot of things when you were on the show. And of course, you have visited and been a requested visitor at many countries representing our judicial system, places like China, and I think Kosovo, among others.
I've met with the judges from Kosovo, been to the Philippines, Russia. I had another inquiry out there tentatively with Tunisia. I don't know if that'll happen. But they would want me to come, if I did come, to talk about elections and how they can run free and fair elections. And I keep coming back to that phrase that I used in a quote, actually, in the Coleman-Franken case, where I said, in a democracy, it's not about the voting, it's about the counting. And it's about the voters not only having the ability to cast their vote, but to have their voice heard. And so hopefully that maybe we can provide some insight into how, if they're going to have an election in Tunisia, that they can do it in a way that is credible. So not only do the people get to cast a vote, but their voice gets to be heard.
And of course, we did see that in 2 recounts in this state. And the interesting thing is, sort of akin to that, they say it's not the crime, it's the cover-up that gets you in trouble. And just today, former candidate for President Edwards was indicted, and not for the crime, but for the cover-up, using campaign money and then lying about it is what the indictment claims. And of course, I give them the presumption of innocence, but it was a 6-count indictment.
It's interesting that you bring that up, because when I talk to young people, I talk to lawyers, young lawyers and ethics, I refer to it as the Watergate syndrome. And I said that I really don't believe, some people do, that Nixon authorized the break-in of Watergate. But he knew about it afterwards. And it was how he behaved once he had that information. And it was very interesting. Just at lunch, I was talking with former Justice Esther Tomjanovich about somebody who got in trouble in the past. And he said, you know, it would have been fine, except he tried to cover it up. Then he lied. And then one thing over the other. And then for lawyers and people, one of the key things in life is, how do you react? How do you behave once you have the information? And so often people don't behave properly. They try to cover up, they think it's going to go away, and then it just compounds, and they don't get charged, they don't get in trouble for the original wrong. But it's what they did after they got the information and tried to cover it up. And people, if I were talking to young people, I say is that that's one of the most important lessons to learn, is to understand the Watergate syndrome. It's often what you do after you have the information, as opposed to the original act itself that gets you in the most trouble.
And actually, Congressman Weiner is going through something very similar to that right now over a photo that was apparently posted on Twitter. He says he didn't do it. But his reaction after the fact is what's getting criticism. Brett Favre, with his use of Twitter. And again, these are all instances of after the fact reactions that get the person in deeper trouble.
I mean, you have this whole syndrome about, I mean, somebody does something wrong, and there's one approach that, you know, you ask for forgiveness and admit it, which is, to my mind, the better approach. But just by asking for forgiveness doesn't mean you're entitled to it. But by far the worst approach is then to try to, you know, deny it and cover up. Because I've been around long enough to know is that, and surely in this modern society, there's somebody out there that's going to talk about it. I mean, and you see it in a crime. I mean, you know, people can't not talk about stuff like this, and it'll come out, and just realize it will.
Well, you just had a case that came down 2 days ago, State v. Ortega, where a man talking about something got him in worse trouble. Now, you had an interesting, you concurred in the conviction, but you dissented with Judge Page in that aspect of it as to whether he should have been, any testimony should have been allowed about him having a lawyer. And that's an interesting follow-through of the same situation.
Well, it is, but we do recognize under our Constitution that you cannot be compelled to testify against yourself, and you have a right to an attorney. And in Minnesota, we've developed a pretty well-articulated concept, is that if I were a police officer interrogating you, and you're talking, and then I get really kind of close to the point that I want to get at, and you say, I think I should have an attorney. Now, my obligation as a police officer at this point is to stop and to minimize, clarify, because you have raised the concept that you understand that you maybe should have an attorney. I can't, as a police officer, go on and say, well, Alan, don't worry about it. You really don't need an attorney, because we're just talking here, and you wanted your story told, and if you want your story told, this is the chance to tell it.
Well, the officer in that case was very shrewd, though, because he then read Ortega his rights. But then he continued on after reading his rights and saying, you know, we can clear this up and we can make it easier if we just dispose of some of these differences from some of the evidence or what we hear from different parties.
That was the point of disagreement in the opinion. No, you have to find out if, Alan Miller, you really want to have an attorney. I just can't kind of ignore what you said or just proceed or to try and tell you otherwise.
Alan Miller probably could use an attorney with him at all times because he gets in a lot of trouble. But
I mean, that's how the law gets made, and obviously is that the rest of the court didn't agree with Justice Page and myself on that point.
And the United States Supreme Court just came down with a case several days ago in which officers were serving a warrant. And the officer said he smelled marijuana from inside the establishment. Now, they could have put it under surveillance and gotten a warrant, but instead they chose to pound on the door, say, "Police, police, police," and then they heard scuffling inside, burst through the door, and they caught the defendant or defendants with some drug.
And I believe the nexus in that case was saying is that there was great apprehension on the part of the police that the evidence might be destroyed.
Exigent circumstances.
And exigent circumstances, when you're in your home, I mean, it goes way back to English common law that your home is your castle. And when the police go into your home, they have to have good reason. And well, we haven't gotten a similar case yet. I know the court was divided on
5 to 4, the usual 5-4, the
4.
4 liberal-leaning judges, with Judge Kennedy being the swing vote, and making it a 5-4 majority, saying that this is another exception we're going to carve out to the Fourth Amendment.
Yeah, and that decision is kind of a consistent in a train of opinions coming out of the Supreme Court. There was another one, I think, out of Utah, maybe about a half dozen years ago, where there was a blind that was out and they saw some movement and whatever. But you know, is that the police have to have a good reason when they go into your home, you know, and I'll have to see how this law develops, but that's an area that I have some, and I've written in the past about some caution about, you know, what is it that you have to do, because the law is well developed. You know, to get a warrant, you have to have a good reason. And if you come up with all these exceptions for why you get to a warrant and it's not necessary, all of a sudden, or not all of a sudden, or over a period of time, that constitutional requirement that says you have to have probable cause for a warrant and do it just kind of all melts away.
And it has been melting away in recent years, especially under this particular court. I mean, Supreme Court,
Well,
U.S. Supreme Court.
you can comment on that, is that, but having, you know, we talked last time about when I was in China, and you talk to people in China and how, you know, they act with impunity there. There's a difference.
When you say they, you mean the authorities.
The authorities,
Yeah.
and there's a difference. And I've talked to any number of people in China who, I mean, in their own homes, they do not feel secure. They, I talked to one couple that, I mean, they had to go out on the street in order to feel that they could even talk about what was a concern on their mind. No, you shouldn't do that in the United States. We're different. We exist under the rule of law, and it should be followed.
Yeah, we certainly hope so. Before we talk about some of the countries that you got to, we are on the verge. We hear a lot about the state having a shutdown, and on the other side of the coin, that a special master will be appointed. And I don't know that people necessarily understand how that comes about. Should there be a shutdown as to what's an essential service and not?
Yeah.
And maybe you could just clarify.
I'm not
a little
sure
bit of
that anybody really understands. I mean, we've had a shutdown in the past. It was a partial shutdown because there were some laws and appropriations that were passed. I mean, the last time through is that the funding for the courts had been passed and approved by the governor, so it didn't affect us. But I mean, when the government no longer has an appropriation for funding, is that it can't continue to operate. except that if you shut down everything, I mean, it will be a disaster. And so now the determination has to be made. I believe a special master is assigned to determine, what is essential, what isn't. I assume that if that's not agreed to, then it ultimately comes to the highest judicial body in the state of Minnesota. It would probably come to us, and that's why I surely wouldn't want to talk about what's essential and what isn't. But it is a very difficult and dicey process, and much of it is unproven area. I mean, I would just say that we just have to be patient and cautious because people will be just kind of feeling their way to see what is essential, what isn't, and how long this thing will last if, in fact, there is a shutdown.
Now, we also have a lot of conflict in the legislature at the moment, and I know that you have limitations as to what you can talk about in terms of the redistricting. The majority offered a redistricting plan, which the governor vetoed, and we now have a process where I guess it's the chief judge of your court
Chief
appointed
Justice.
5 other judges, I understand, with varying backgrounds.
Well, yeah, the Chief Justice does appoint. To her credit, she consulted with the rest of us on the court, and I can go so far about this year, and then I'll maybe talk about history. Is that if you look at the makeup of the panel, it's the presiding judge is a judge of the Court of Appeals, Judge Wilhelmina Wright. She's very well respected, both in the state and externally. And then you have some geographic diversity on the court. You have a Judge Flory from the Iron Range. You have Ivy Bernhardtson, who's from Hennepin County. You have Judge Edward Lynch from here in Dakota County.
And Judge Lynch was a guest here within the last 6 months.
And then is Judge Rodenberg from down in New Ulm. So now you take a look, is that it's geographic, population-wise, is to give some perspectives. So at this point, with respect to this year, is that I really can't say too much more that other than a panel has been appointed. But I mean, it's not rocket science. As anybody's looking how this thing is going to sort out and work, I mean, you can look at history. I mean, the only time since that there's been the required redistricting that the legislature got it done was in 1962. Elmer L. Anderson was governor then, and they had a special session. They came to some agreement. I think it was in October that they got it done. I think it was October of '61 coming into the '62 election year. Ever since then, it's been decided in the courts, in the '70 census and the 1980 census, resolved in the federal courts. There appears to have been a seminal change in 1990, and since then is that the U.S. Supreme Court has given more of the authority to the state courts. And so 10 years ago, the court appointed a 5-judge panel. Judge Toussaint from the Court of Appeals was on it, Tom Kalatowski from the Court of Appeals, and then you had Judge Paglicetti from the Iron Range, and Nay Werke from southern Minnesota, and Heidi Schellhaus from Hennepin County. So I mean, it's, you see, oh, there's a similar pattern here. The court is trying to appoint people from a basis. Only difference maybe this year from 10 years ago is that we're looking at a tighter deadline because we have an earlier filing deadline now at May instead of July, and we have a primary in August. And so 10 years ago, the panel got appointed in July, I think. This year it's in June, maybe reflects that tighter deadline. But people don't have to speculate and just see what they did 10 years ago. There's a template to look at. And I'm very proud.
They did a nice job 10 years ago.
At 10 years,
and
I think it's
really representative of the population basis in the districts.
And I'm really proud of that panel because I think it's the only judicial redistricting in the nation where it went to the courts and there was no appeal. The panel came down with its decision on March 19, 2002. There was no appeal. I mean, people could nitpick and disagree, but said overall this is a very fair plan. And one of the things that panel did is very good. A couple of things. One, early on that panel invited all the parties in and say, you know, what do you think the guidelines and rules should be? And as a result of that process, they came up with some standards that they were going to follow. And most, you know, all the parties agreed on over 90% of what the criteria is going to be. But the other thing that they did is they held hearings throughout the state. And they invited mayors and county commissioners and others. What works for you? And you know, they heard from mayors saying, don't divide our city. They heard from county commissioners, don't carve up our county. And so they, so I can't say too much what this panel is going to be doing going forward because they are appointed, now they're in charge of it. But look and see what happened 10 years ago and you'll get a pretty good idea of a template, how it's going to work.
And I think we can rely pretty much on the integrity of the courts in this state
Oh, yes.
to be eminently fair in how they do it, as opposed, and I frankly think it should go to a panel of judges immediately after the census, you know, is complete and comes out, rather than get into this political nitpicking where the party in power, unless there happen to be two parties that have to compromise, where the party in power just creates districts that are completely not representative of the population appropriately.
And understand is that my view as a Supreme Court Justice, I have a strong vested interest in having this 5-judge panel do it well and do it right. I was never so happy as anybody is that in 2002, I was on the court then, no appeal. I mean, we didn't have to deal with it. It was done well and didn't have to come to our court. So I would hope the same scenario comes to play this time around.
Now, you are the second longest sitting justice on the court at the present time. Justice Page, I think, has
He
been on a little
predates
bit.
me by a year and a half.
You are, by law, coming to the end of your term. We talked the other day, the fact that on May 31st, 2 years from now, your term will be up.
Yep, it will.
So what has been, in your estimation, the highlight and the low light, or if there is such, of your
That's
almost
Alan, that's a
17
good
years on the court?
There haven't been many lowlights. I mean, I consider myself one of the most privileged people in the world that I have a chance to serve on the Minnesota Supreme Court. And I decided early on that there's no way to explain how I got there. I got appointed by Arnie Carlson. He had a degree of respect for me and he knew me. And so I've approached it with the attitude is that it is a privilege. And it's a privilege I got to earn every day that I'm on the job. And this may seem, but I think about it all the time. Some of the most satisfying things have been to work through an issue and an opinion and believe at the end you got it right and you sorted through a difficult problem. Some other highlights, interesting, you know, I'm talking to students and groups 2-3 times a week when schools, and this morning I've already talked to 2 groups, so one from Prior Lake and another from St. Ambrose School, and I had some teachers come up to me and said, that was spectacular. He said, you are really a good teacher. You made it understandable and the students are going away from here with an idea of how government works. That's a highlight for me, that I'm in a position to explain how this system works. So I've been able to do a lot of outreach. That's been a real highlight.
You've worked with a lot of judges who have come and gone, including multiple chief justices.
Yes, and I've worked with some very good people. I mean, I'm very, very, very pleased. And a little bit on the other side, it was very interesting earlier this week. I was at a on a panel dealing with Innocent Project and showing how justice had gone wrong down in Louisiana. And it had gone wrong with these defendants. They had spent a horrendous amount of time in prison, and most all of it in solitary confinement. And I was really dismayed, and they showed how imperfect the system is. And one of the people in the audience was someone who had represented people in the South, in Louisiana, and was very passionate, but was very cynical in the sense that there is no justice in this country. And he said, how can you say there's justice when things like this happen? And I sat there, and do I remain silent or do I speak up? And I said, sir, I said, I've seen countries where there is no justice. I can take you back to China and others. For you to say there is no justice in the United States is wrong, and it's very cynical. Our system is populated by human beings, and it's imperfect, yes. But there are many who try to do the right thing. And then I addressed the rest of the population. I've talked about you on this show before. I said, you know, there are many people who want to turn us into a nation of cynics, and we can't allow that to happen. Be skeptical. Question me all the time. But don't come with this attitude that it's cynical, and because then you turn off. Then you pick up your marbles and go home. And there's too much great about our country to do it. Let's try to correct those imperfections. If the Attorney General in Louisiana has a deaf ear to what we consider justice, figure out a way to change it. But don't rant and rave and try and turn us into cynics. And so that kind of goes back to the thing that you asked. One of the more satisfying parts of my job is that I can fight cynicism. I can encourage discriminating irreverence. I can encourage skepticism, but I'm in a position to fight cynicism, and I'll continue to do that.
And just that attitude is the reason why you are probably by far the most popular judge asked to speak to civic groups, asked to speak to students, asked to go to other countries, asked to go to developing nations, because of that deep-rooted philosophy within you that really, really speaks so well of the judicial system in this country and of you.
Now,
And,
I got to tell you something.
and
My
we have less than a minute.
My parents deserve a little credit for that. I mean, both the way I was raised and my genetic code. I mean, I'm not intimidated about going out and speaking, and I love to respond to a challenge and questions, and so you know, that's another thing. I'm very fortunate in kind of how my makeup comes together that allows me to do that.
Justice Paul Anderson, always an education, always a pleasure.
Are we out of time again?
And we have less than half a minute, so that I just want to thank you again for your 17th appearance. It shows your perseverance also.
Yes.
Willing to come back and face me that many times.
Can I quick say, one of the challenges of my job is coming and on your show, not knowing what you're going to ask me, but then coming here and trying to answer your questions. I love good questions. That's another exciting part of my job.
I thank you so much.